Namaste, good afternoon. So we are starting our webinar for Sunday afternoon, and today the subject is NCLT judgments, which we find are important for the stakeholders. And I have with me Advocate Amar Vivek. He has also contributed in analyzing these judgments. Ankit Goel will join a little later so that we can start the webinar. So the primary objective of discussions on NCLAT judgments are, although the judgments are many, but then we have selected few judgments which are important for all the stakeholders and which are somehow establishing a law. So I'll start my screen. Just give me a second. So this is in fact part 2 of our judgments. Last Sunday we delivered and deliberated on some Supreme Court judgments and 2 NCLAT judgments, and today we will take up the other NCLAT judgments, and we'll start with the first one for the today is the Assam Tea Employees Provident Fund Organization versus Madhur Agarwal, which is the RP of Hale Tea Limited. So the corporate debtor in this case is Hale Tea Limited. RP is Madhur Agarwal, and the applicant is Assam Tea Employees Provident Fund Organization. So now this Assam Tea Employees Provident Fund Organization is something that we need to understand, because this is not an employees. So this means that the company is managing its own provident fund. This is that scenario, because this organization seems to be a non-governmental, maybe it's Assam Tea Employees. So there may be a government organization which is restricted, which is dedicated to Assam, and it is dedicated to tea employees only. It sounds like that. So anything that you found about this provident fund organization? So normally we have in India the Commissioner of Provident Fund, and this name seems to be Assam Tea Employees Provident Fund. So I just want to understand, it is a private one or it's a government one. Anyway, we can in case there was nothing in the order, so we cannot comment on this. However, the law that we are talking about is different, whether provident fund dues can be treated as secured debt and be payable in full. So the question is slightly different. So far, we've been saying that the provident fund dues are not even part of the assets of the company. So this application is slightly different. Now, in this application, what has been the claim? Because the applicant, which is the Employee Provident Fund Organization, submitted a claim of about 2.10 crore, and the same was admitted by the RP at the same 2.10 crore. Now, the said claim, on account of the default on the part of the corporate debtor, it was basically contains the provident fund contribution of the employees and the employer provident fund administrative charges, interest for delay in deposit of provident fund dues, interest for delay in deposit linked insurance dues, and provident fund contribution due and payment for the period commencing from 28th March 2019 till 26th September 2019. Not a very big period, but it is only about 6 months' time that the provident fund was not deposited. In the resolution plan approved by the adjudicating authority, the amount which was proposed to be paid to the provident fund organization was 1.07, which was almost 50% of the total claim. So therefore, the appeal was filed by the provident fund organization. Now, the appellant means the provident fund organization said to the court that the dues were supposed to be paid in full because the claim was admitted by the RP to the extent of 2.10 crore, and it was required to be paid in full because this is, in case it is not paid in full, then it is a contravention of section 30 subsection 2 clause E. Now that section 30 subsection 2 clause E is not the section which talks about that the provident fund dues are not even part of the assets of the company. So that is under liquidation provisions, not in the resolution. So because in this case, the resolution plan was approved, therefore the appellant said that the section 30 subsection 2 subclause E is applicable, where it is said the resolution plan does not contravene any of the provisions of the law for the time being in force. And it was alleged by the appellant that the resolution plan is contravening section 11 subsection 2 of the Employees Provident Fund Act 1952, and it is submitted that the provident fund dues are not dues of any other operational creditor. Now here the section 11 subsection 2 of EPF says, without prejudice to the provisions of subsection 1, if any amount is due from an employer, whether in respect of the employee's contribution deducted from the wages of the employee or employer contribution, the amount so due shall be deemed to be the first charge on the assets of the establishment and shall, notwithstanding anything contained in any other law for the time being in force, be paid in priority to all other dues. Now, this is the section 11 subsection 2 of EPF Act. One can always say that the section 238 of the IBC says that the IBC overrides all other law. So whether this section 11 subsection 2 of EPF overrides the IBC, so it's not that it overrides. Although this particular paragraph is almost matching with Rainbow Paper Mill judgment. Rainbow Paper says that the charge on the assets based on any amount due to statutory authorities, that actually would be considered as a charge, and those dues would be secured operational creditors. That's what is the Rainbow Paper says. Now, in this case, the applicant in fact claimed the similar situation that there is a charge, there is a first charge on the assets of the company because the provident fund was due. Now, this was the appellant's submission. This respondent simply said that the approval of the resolution plan is in the domain of the commercial wisdom of committee of creditors. Haircut has been given to all the financial creditors and operational creditors. Therefore, the haircut to operational creditor, which is the provident fund organization, is also valid. That's a only one response from the respondent. Now, the NCLAT in this case did not apply Rainbow Paper. Let's see what is the judgment date and whether the Rainbow was there on that day or not. The judgment is on 2nd of November 2022, and that means that the Rainbow Paper was there. The NCLAT could have used the Rainbow Paper, but the NCLAT has not used Rainbow Paper and has used this in the case of Jet Airways, the Regional Provident Fund Commissioner versus Ashish Chocharia, the RP for Jet Airways. So this judgment was used, and again it was an appellate authority judge. It was appellate tribunal judgment, NCLAT judgment. In that judgment, the NCLAT has already held that the expression any amount due from an employer appearing in subsection 2 of section 11 has to be interpreted keeping in view the object of the Act and other provisions contained therein, including subsection 1 of section 11 and section 7A, 7Q, 14B, and 15.2. So these 4 sections are pertaining to any dues payable by the employer and the liability of the employer to pay interest, and also the payment of the payment of the amount due is if it is delayed, then also pay damages. So these are the sections which are saying that the employer will have to deposit amount due interest and the damages. Now, in this case, based on this Jet Airways judgment, the provident fund dues are not the assets of the collateral. They have to be paid in full. The provident fund dues are not subject to distribution under section 53(1) of the code. Now, in this case, finally, the appellate authority said that the provident fund dues are not the asset and it has to be paid in full. So the total amount of 2 crores was directed to be paid. The provident fund dues are not subject to distribution under section 53(1) of the code. That is again reiterated by NCLAT again and again. So we all, so our like in, see, what do we deliberate? So regarding provident fund, gratuity and pension fund. So present situation is very clear. NCLAT is reiterating again and again that the dues are not the assets of the corporate debtor, even if there is no asset in the company, but there are provident fund dues. So that means the dues are, those kind of assets will have to be earmarked separately, which are sufficient for payment of provident fund, gratuity fund, and the
Sir, in cases we'll see, we are more seeing in recent cases, especially dealing with provident funds in case of insolvency, is that the use of section 11 subsection 2 has enabled the adjudicating authorities and NCLAT to come to a conclusion that the charge is there. Once a provident fund, even if would have been deducted and provisioned in books of the corporate debtor, then the charge is created by that criteria on the assets of the corporate debtor under subsection 11 subsection 2. Now the only thing that remains, and we can draw a distinction between this judgment and Sawan Godiwala, is that Sawan Godiwala went a little further to the extent that it said that in case the provisioning under the books of the corporate debtor has not been done with regard to employees provident fund dues, then that would, in that case, it would come under section 53(1). But if the provisioning has been done in the books of the corporate debtor, then that provisioning is to be regarded separately from section 53(1), and it will be paid in entirety as per section 11 subsection 2.
But then this, when we see section 11 subsection 2, it only talks about lien on the assets of the corporate debtor. Now, when we talk about lien, so the lien would be basically, it will be secured operational creditor. When it becomes secured operational creditor, then they would actually get pari passu proportionate to other secured creditors and workmen. So, but that's not full, because in this case, even the secured creditors are also getting some haircut. So that's not full. Why the NCLAT has given the full amount to the provident fund, that is only with regard to the section 35 or rather 36. So otherwise, the section 11 subsection 2 of the Provident Fund Act, had it been applied like rainbow, then this would have been secured operational creditor. But they have said that it will be paid in full. So that means they've applied the section 36, I think 36 2B4. That's the section which is they have applied. So what do you say? So how do you, what is the kind of directions that we can have? Welcome, Ankit, and you can also change your name because you're still, or I can change.
Just doing that. Just joined in, so I'm just doing that.
So with regard to employees provident fund dues, one thing we can say that in case of resolution plan, these dues have to be dealt separately. Now, NCLAT has bifurcated between the process that is carried up in the cases of liquidation and under the resolution plan. Now, why they have done that, the particular reasoning of relying upon this Jet Airways judgment was that the Jet Airways for the first time created a bifurcation of treatment of employees provident fund dues under a resolution plan and clearly say categorically observed that employees provident fund dues, if the provision has been done, they have to be paid in entirety. Subject to that, you make payments under the resolution plan. Now that is the subject caveat that was added under the through this judgment, that you make payments of the employees provident fund dues first in entirety, then you come to the proportionate distribution, because that due is with respect to due arising out of a particular law uh, under Employees Provident Fund Act 1952. But other with respect to other stakeholders, they have their share with respect under IBC.
So again, I am saying one thing. So Ankit, we are discussing this provident fund judgment, which has come narrating section 11, subsection 1, subsection 2 of PF Act, where it says that any dues of PF will have first charge on the assets of the company. So in case we are talking about the first charge, then it will become a secured operational creditor, where the judgment has been given as full amount has to be paid. So we are still saying that the section 11 subsection 2 is not used, but again the section 36 has been used, that the total amount of the provident fund dues that should be paid, it is not part of the assets of the corporate debtor. So in this case also, there was no provision, it was only a claim which was admitted. So I think we can still say that this the provisions which is used for this judgment is not 11 subsection 2, because had it been 11 subsection 2, it would have been proportionate with other secured creditors and the workman.
So I think like PF dues are something that are statutory dues because it's like payable under an act, but at the same time they benefit the workmen. So there is a hybrid nature of these dues. At the same time, saying that irrespective of section 53, we say that the PF dues have to be paid in full before any other payment. Generalizing that and kind of adopting that approach might be difficult in many cases where if you pay all the PF dues and there may be nothing left at all for other stakeholders, creating little incentive for the resolution to be completed or the company to be revived. So I think as we were discussing yesterday at the SHM conference, there needs to be more clarity on this, and this needs to be revisited, because the whole issue is created with the idea that the fund which is used or which is created to pay these dues or pay these payable amounts, whether it is gratuity, PF, superannuation, or any other such dues, that fund, if not created, then what would be the case? If the fund is created, then it is very clear that the fund will be used for these payments and the fund is not part of the company's assets. But what about those companies who have not been able to create that fund, or the fund has a deficit in the asset base to cover up the liabilities? That needs to be taken care of, maybe in the IBC or the regulations for clarity.
I think Sawan Godiwala makes some clarity, but even after that Sawan Godiwala, there are now 3 or 4 judgments which are saying that the provident fund dues, gratuity dues, and the pension fund, these would not form part of the assets of the company. So I think we can, for the time being, conclude that the not the assets of the company is the essence of this judgment, and not something which is secured operational creditor. They have not used it as secured operational creditor, although they have used section 11 subsection 2 of EPF Act, but they have not given this claim as secured operational creditor. Rather, they actually thought that this should be kept outside the assets of the company. I think we should move forward to the next judgment. This is Shubh Gautam versus Anjani Technoplast, again an NCLAT judgment, and as recent as 1st of November 2022. Whether a decree comes under the purview of section 5 subsection 8 of the code, that is the definition of financial debt, or not, that's a main issue in this case. And the facts of the case is the appellant had granted 2 loans to the respondent by loan agreements, and the respondent was unable to pay, so there was a high court application filed by the lender, and also Delhi High Court gave a decree to the lender. And now after even taking the decree, the amount was not coming from the CD. So therefore they kind of filed application under Section 7 before the NCLT. NCLT in this case dismissed the application, saying that it is not a case of Section 7 because the decree as such would not become financial creditor. By the decree holder will not become financial creditor, and further held that in view of the facts and circumstances of the instant case, the debt in question, which is included in Section 7 application, does not come under the plea of financial debt. So the again definition of Section 5 subsection 8, it was used by NCLT by saying that the decree is not a financial asset. Now the appellant, who is a lender in this case, stated that financial assistance of 4.5 crores was given, 2 loan agreements, because there was a default, so the Delhi High Court recovery was filed, and 2 loan agreement established in the relationship of financial creditor, because the agreement was there, time value for money was also there. So both these things were there. So it was a financial transaction. Then the respondent said that the alleged, because the respondent now, while responding, in fact, had actually gone to a different way, different path. The respondent was not arguing whether this is as per Section 5.8. There was no argument. The argument was that the lender has manipulated books of account, and it has been misrepresented before the High Court of Delhi, and therefore they could get the decree. The decree is non-est in law and should be set aside. Now the decree has been passed by High Court, and NCLAT has got no jurisdiction to set aside that. So the respondent in this case was not really arguing on Section 5 subsection 8. That means the financial debt or not. So the respondent was only saying that such a decree cannot provide cause of action. Now, so there are 2 things involved into this, whether it's a debt, financial debt, as per the definition given in Section 5 subsection 8. This is number 1. Number 2, whether when the decree is given, would that actually again restart the period of limitation? So these are the 2 issues involved in this. So let's see what exactly the NCLAT held in this case. And NCLAT said that we rely on the Supreme Court judgment, which is in the name of Dena Bank. Earlier it was Dena Bank, now merged with Bank of Baroda, versus C. Shiva Kumar Reddy in 2020. It was already held. And in fact, this particular judgment was primarily on limitation. So the paragraph which has been taken is the judgment on limitation law, because it is held here that the moreover a judgment and a decree for money in favor of the financial creditor passed by DRT or any other tribunal or court, or the issuance of recovery certificate in favor of the financial creditor, will give rise to a new cause of action for the financial creditor to initiate proceedings under Section 7 for initiation of CIRP within 3 years from the date of judgment or the decree. So in this C. Shiva Kumar Reddy, in fact, it was primarily on decree, and then 3 years from the date of decree. That was the judgment. However, in this case, NCLAT has used that. NCLAT has used this particular judgment that the loan and then decree, it is all valid. And then finally, NCLAT held in this case that the NCLT has added, and the judgment or decree of money in favor of the financial creditor passed by DRT or any other tribunal or court would give rise to a fresh cause of action for the financial creditor to initiate proceedings under Section Section 7 of the IBC, and the decree is a financial debt if underlying transaction itself is a financial debt. So any comment by any of you on this? Because what I'm trying to say, that one issue handled by this is the limitation, and the other is the definition of financial debt. So the decree is a financial debt, and the limitation restarts from the date of the decree. Any comment that you would like to add?
I think it's fair. I think it's clear we can move forward and look at the next one.
The next
Unless
one is
Amar has
Prashant. Amar, do you have anything to say on this
Sir,
particular
it's
judgment?
just that you already had a webinar on this Dana Bank judgment and
Right.
Sri Shiv Kumar Reddy, and we dealt in detail about the underlying transaction, which Supreme Court said that would always be looked upon while determining. Because if you remember, there was another judgment of Supreme Court which came from Tripura High Court in C. Baumik versus Union of India, in which Supreme Court said that in this case, decree is not a financial debt because the underlying transaction is of an operational debt nature.
But see,
So
basically in that judgment, it was held by Supreme Court in this C. Sivar Kumar Reddy, like the decree does not change the nature of the transaction.
exactly, sir.
The decree is a fall. It's a natural action of recovery. However, that was impacting the limitation period. So the decree does not change the nature of debt. If it is a operational debt, originally the decree also would be an operational creditor decree holder. So that's like, I think this is a good addition by you, that even the Supreme Court at that time handled two separate issues. The decree is not supposed to be defined. Decree is only the original debt is supposed to be seen. Prashant Chandra Rath, the suspended director of corporate debtor versus Suryakant Satapathy, the resolution professional. The judgment is from NCLAT and date is 30th of September 22. Now, in this case, whether there is any scope for resolution professional to take any action for fraudulent transactions covered under section 43, 45, 50, and 66 of the IBC beyond the timeline stipulated under CIRP regulation 35A. Now, the 35A, see, basically the facts are that the RP filed an application under section 66 of the code. The application was filed beyond 130 days, 135 days in the insolvency, because see, 130 days is provided, the days are provided under regulation 35 capital A, but in this case, the RP was not able to file that application, was not able to frame an opinion, determine the amount, and file an application within an overall period of 135 days. So that was the reason where the promoter, where the order was passed, the promoter filed an application. Now, the NCLT condoned the delay in filing of the application under section 66, declared the transaction as fraudulent, and accordingly directed the directors to refund the amount. Aggrieved by the same, the appeal was preferred before the Honorable NCLAT. So the relevant provisions, we can say regulation 35A of CIRP regulation says that on 75th day, we have to form an opinion, 115th day, we have to determine the transactions, and then within 135 days, and that has to be submitted to the adjudicating authority for adjudication application under section 66. The appellant says that the regulation 35A prescribes clear timeline, and it further says the applicant in this case is promoter who's been proceeded against. That the timeline prescribed by the regulation 35A is of special significance in the present matter, since here the promoters are eligible to act as a resolution applicant for the corporate debtor being MSME. So, since the successful resolution applicant or the applicant was also one of the resolution applicant because of MSME, so the RP said that in this case it is more important that all these applications which is already submitted to adjudicating authority under COFE transactions should be decided first before even the resolution plan is approved, because the resolution plan again from the same promoter against whom we are proceeding. So that's the main issue. that in case Section 66 is orders are passed, and then it becomes, in case it is ultimately upheld, yes, the damages to the promoter is right, then it might even be difficult under the MSME Act to continue as partner or director. Now, the respondents also said that there was a proposal of OTS which actually delayed the audit. Then the RP also said that there was non-cooperation from the CD, and they were not submitting times and accounts, and therefore the delay had happened. And finally, the NCLAT said that Regulation 35 capital A of CRP regulation is directory and not mandatory in the nature, and so no consequential effect is mentioned under such regulation for non-compliance of the time limit, and reliance was placed on Shaji Purushottam versus Union of India, Madras High Court order. So what we are taking home, number one, 35A regulation timelines, which is 105, 115, and 135 are only directory and not mandatory. Secondly, is by just doing a little bit of delay, there is no consequential effect. So therefore, the delay was somehow permitted, it was allowed. And any comment on this, please?
No, sir, I think it's all covered.
I think it's clear that you can't use this excuse and say that, oh, the transaction avoidance should have been filed within this timeline. I think that defense will not stand for any avoidance transaction, and then that's clear here.
But the defense actually has stood in this case. The NCLAT has allowed the condonation, and
yeah,
saying,
so defense means that defense on part of the resolution, the CD's management. The CD's management tried to put in a defense that because the application is filed late, it should be thrown away. So the CD is expected to fight on other grounds based on the nature of transactions.
So because we have seen a lot of cases practically wherein the first line of defense, as Ankit sir rightly pointed out, the promoters uses that the application has been filed after 135 day, so dismiss it. And NCLT initially ordered for few applications to be dismissed on this very ground. But since now NCLAT has provided this clarity, I think it will not be an issue for RP and liquidator, importantly.
So knowing this judgment is important then for all people who are fighting that argument, which is, as Amar said, is used by the management of the CD.
right. So I think we should move on to the next one, that is Chipson Aviation Private Limited versus Punj Lloyd Aviation Limited, NCLAT judgment dated 10th of November 2022. Again, a kind of a repeated kind of judgment, because the advance was paid by a customer to aviation company for getting a service. Basically, advance was paid to the corporate debtor, and advance was paid for taking some services, and whether it should be considered as an operational debt or it should be considered as a financial debt, that is the issue here. So in fact, the advance was given for some services to be taken by an aviation company. The contract was not signed. Since the money was not coming, the services were also not coming. So the customer who has given advance filed an application under Section 9, and the NCLT dismissed the application under Section 9, saying that on the ground of holding advance payment made by the creditor to the corporate debtor does not fall within the four corners of operational debt. So therefore, the appeal was filed. Now, appellant said the advance was paid towards obtaining goods and services. The balance sheets of the corporate debtor shows that the 60 lakhs has been received as advance from customers, and that also tantamount to the acknowledgement. So there is no issue regarding the limitation. Then Reliance was placed on consortium, the Construction Consortium Limited versus Hydro Energy Solutions Private Limited, 2022 Supreme Court case, wherein the Honorable Supreme Court has held that the advance payment for goods and services is an operational debt. And the line used by Honorable Supreme Court was a debt which arises out of advance payment made to a corporate debtor for supply of goods or services would be considered as an operational debt. Although we have section 58F, but the Supreme Court and the NCLT or NCLATs are not using it. The respondent said that there is no privy of contract between the parties. Advance payment cannot be considered as operational debt. And finally, the NCLAT said that section 520, subsection 21 says that the expression in respect of the provisions of goods or services means provisions of goods or services is one line. Section 521 has to be interpreted in a broad manner. That the advance payment of 60 lakhs was made for availing aviation services and is clearly an operational debt, and the adjudicating authority committed error in rejecting section 9 application. Reliance was placed on Construction Consortium Limited versus Hydro Energy. So in this case, the advance was held as operational creditor. So in case any advance is given to any company, and we were earlier thinking that it is it is financial debt, but multiple judgments came and it is not a financial debt. That's what we could see. So the next is Chhattisgarh State Power Distribution Company Limited versus Salasar Steel and Power Limited, NCLAT judgment dated 30th of September 2022. Whether the resolution professional is under legal obligation to inform the fair liquidation value of the corporate debtor to the appellant operational creditor who is not a member of the COC. So there was an operational creditor like the Haryana, basically the Chhattisgarh Electricity Department, you can say it was an operational creditor for about 40 crores. The operational creditor was not paid much and the resolution plan was approved. Now the operational creditor, like the Electricity Department says that the resolution professional is under obligation to inform the fair and liquidation value of the corporate debtor, because the operational creditor had the law, and the law said that the operational creditor will get minimum amount, minimum liquidation value due to them. So he was saying that the no minimum amount, the liquidation value is not even shared with us. So that is the basic allegation, that the liquidation value was not even shared with the hotel. And we've been saying that we have to raise bill. So they finally raised a bill which is not acceptable now. But the facts that the appellant was one of the OC of the CD. The resolution plan was duly approved by the NCLT as against total amount of 48.38 crores of operational creditor, but without any actual assessment of the liquidation value. So this is the case, and let's see what happens. In the appellant says that the appellant was not a member of the COC, no opportunity was given to participate into the COC. Decision taken by COC is not binding. The liquidation value of the CD was not intimated to the appellant, and the RP failed to appoint registered valuer for assessing the limitation. I think this is that last line is not real workable. The respondent said that the liquidation value was kept as confidential and cannot be disclosed. Regulation 35 mandates disclosure of the liquidation value to members only. So the court held that Regulation 35 mandates disclosure of liquidation value to the members of the Committee of Creditors. Since the appellant is not a member of the COC, to provide failure to provide the fair value or liquidation value to the applicant is not the ground to set aside the order impugned in the appeal while exercising the jurisdiction. So the order for approval of resolution plan was, in fact, that was not coming before, because see, once the creditor decide between themselves, then only some decision can be taken. So finally, it was held that the Regulation 35 talks about the disclosure. The appellant is not a member of the COC. Failure to provide fair value and the liquidation value to the appellant is not a ground to set aside. Therefore, the contention of so it was not allowed to be set aside. So the only issue was that it should be set aside or not. Resolution plan has been approved, but it was not set aside. It was not set aside. In the resolution plan, the amount was offered. So but that was not. So finally, it was held that whatever RP has done is the right thing. There is no non-compliance by the RP. So I think Amar can take up this Subrata Maiti versus Amit C. Podar and others again, 13th
Yes.
of October judgment of.
Yes, sir. In this judgment, this is
So before we proceed, like when we are passing a resolution plan, and let's say the resolution plan is approved by the COC, at that point in time, what should be the communication or that should go to the operational creditors? Because many times operational creditors will keep following up that, oh, I had some dues. What is what is my right? How has that been cleared? And we will give them a status update on what the status of the plan is. Because not being part of COC, they are in the dark room. They'd have no idea what is going on. So what do you recommend? Because they are also stakeholders of the entire process, and what should be the normal course? You can't share the valuation report with them, but what other information or important information post CRP, post resolution plan approval should be shared with them?
I think now the regulations have been changed. It is the obligation of the RP that post approval of the resolution plan, the RP is supposed to communicate with each and every claimant and will inform those claimants few things. The first thing is their claim, their admitted claim, and then finally what was the liquidation value due to them, and how what is the rationale of offering the money to them, which is lesser. What is the rationale? So all things that individual communication to each creditor is supposed to go from the RP. So now this.
But the creditor will not be able to see the computation of liquidation value, or rather computation of liquidation value based on the valuation report. That he still can't do.
That he still can't do, because the court has held in this case also that it is correct that the liquidation value is a confidential thing. It was held. And now yes, please.
So Subrata Mathi versus Amit C. Podar is a judgment of 13th October 2022 NCLAT. So it is a peculiar case. We know that today after the amendment, the regulations have been amended, and even the liquidator can be replaced by the SEC after a vote. Now today what we see that whether the question before the NCLAT was whether exercising their powers under Rule 11, that is inherent powers of NCLT, whether NCLT can replace a liquidator of the corporate debtor.
Yes.
So what happened, that liquidator of the corporate debtor was arrested for some case that was initiated before CBI, and thereafter an application was filed by SCC, and SCC doesn't make liquidator a party to that application, and does not even serve that application to the liquidator. Thereafter, what happens that NCLT passes an order for replacement of the liquidator. Now, liquidator prefers an appeal against that order and says that I was not made even a party to that application, and that is per se violation of my principle of natural justice. Moreover, I was not even served with a copy of that application. So this order per se is devoid of merits on first ground that NCLT has erred in exercising its power of Rule 11 in the absence of any provision of law, and second of all, it is in violation of principle of natural justice. So NCLT NCLAT, while determining this facts and ratio and the case laws, clearly categorically holds that NCLT under Rule 11 can exercise its power for doing substantial justice whenever there is absence of provision of law. So in case when there is no provision of law which stipulates for replacement of liquidator, but the circumstances of the case requires a liquidator to be replaced, then in that case for doing substantial justice, that's why NCLAT emphasized more upon this term of substantial justice for exercise of Rule 11, and categorically says that NCLT has all the powers to do substantial justice under Rule 11. So the order of NCLT replacing the liquidator was not interfered with, and liquidator stood replaced.
So I think now this with the amendment to the liquidation regulations, this anyways loses this uniqueness. So this, although this case law is good, but then now the COC has absolute power in case something like this happens now, and 66% of the COC decides to change the liquidator, then the liquidator won't have a opportunity of being heard in NCLT.
So one thing but becomes clear from this judgment is that this, in case there are certain situations, suppose we who can propose a 12A and what sort of settlement can come through 12A for settlement, we have seen use of this rule 11 a lot. So, and that rule 11 is used, that has been clarified by NCLAT to the extent that whenever there is absence of provisions under IBC, you can come to rule 11 if the merits of the case require substantial justice.
I think it is very, very correct interpretation. And moreover, when it comes to the RP or liquidator's life, whatever decision has been taken by adjudicating authority, NCLAT has never said that they had no power. It is always maintained that whatever NCLT does against any of the RP, that will be upheld. So the next judgment is Almas Global Opportunity Fund and versus CA Kanan through Vangadam. NCLAT judgment 21st of October 22. Now in this judgment, it is a very simple case. The chairman of the monitoring committee has a locus to file an application under section 33 subsection 3 is contravention of the resolution plan and filing of an application for liquidating the company. And the second question was, since the resolution plan was not implemented by the successful resolution applicant, so whether the adjudicating authority can use section 74 and pass some order or not. So this was the judgment, and in this particular judgment, the resolution applicant was approved by the committee of creditors. However, the resolution applicant did not pay earnest money deposit and also the performance bank guarantee, which was also part of the resolution plan and stipulation. Then various reminders, whatever, everything was done. And finally, the money was not coming. So the chairman of the monitoring committee, who was the RP, filed an application praying for the forfeiture of the amount and for initiation of liquidation. So that is what something which is required to be done by any monitoring professional monitoring committee, that the performance guarantee may be invoked, the liquidation may be started. Now the adjudicating authority said that the bank guarantee forfeiture was allowed, and also issued a direction to reboot CIRP and issue fresh Form G. And the the application was to initiate liquidation. However, the adjudicating authority said that you forfeit the earnest money deposit and start afresh and issue fresh Form G. So the adjudicating authority did not liquidate the company, and also issued directions under section 74 subsection 3 of the code or proceedings to be instituted against the appellant and its officer for contravention of the resolution plan. So this finally NCLAT said that these directions under section 74 subsection 3 is not under the jurisdiction of the adjudicating authority, and however the bank guarantee can be invoked and can be forfeited. The appellant in this case said the order where the company was pushed for CIRP, and it was rebooting of the CIRP rather than liquidating. And the adjudicating authority, this was the appellant said, adjudicating authority has no power to restart the CIRP. The delay, the RP to CD could not be prejudicially affected by the delay in non-implementation of the resolution plan. therefore did not have locus to file an application. So then the other was the monitoring agency or monitoring committee chairman is not empowered to file an application under Section 33 for liquidating the company. So the adjudicating authority was not empowered to pass the order under Section 74. This is what is the appellant's submission. And the tribunal said, and it should be very important, the tribunal said, in fact, we also at one point of time asked our creditor to file application for contravention because the liquidator may not have, but however the NCLAT made it very clear, monitoring committee or monitoring professional or the chairman is fully entrusted with the power to supervise the implementation and hence had a locus to file present application. And also when the plan has failed to be implemented by the RA, it was also the duty of the monitoring committee to bring it to the notice of the adjudicating authority, relevant facts, including the forfeiture of including the failure of the plan. Ask for further directions from the adjudicating authority with regard to the CD. The Honorable Appellate Tribunal thus did not find any substance in the submission of the counsel for the appellant that respondent has no locus. So it was very clear the monitoring committee has powers. And the second decision was that under Section 74, which is under offenses and penalties, which is under Chapter 7 of the IBC, and 236 very clearly provides that the trial of offenses would be the jurisdiction of special court constituted under the Companies Act. And therefore, the filing, so the Section 74 offense can only be filed under Section 236, where presently IBBI is empowered to launch prosecution against anyone under all the offenses and penalties, because this is not to be delegated. That's what is the current opinion from the, I think the next order, Small Industries Development Bank of India, SIDBI versus Vivek Raheja. So
let me take this up quickly. So this is again
this is regarding Ankit, this is regarding that issue.
We discussed that. So this is with respect to the pending matter in the Supreme Court of India with respect to how to understand the waterfall mechanism. And in this case, SIDBI was a 7% dissenting financial creditor having substantial security. However, when the resolution plan came in and the resolution plan was approved by other financial creditors, the plan did not allocate the amount payable to SIDBI was allocated based on their voting share in the COC and not based on their security. So they went to NCLAT here, and NCLAT, this is a Chandigarh bench judgment, and subsequently they went to NCLAT, and NCLAT has in this case decreed that no, the distribution that has happened for SIDBI is right, because the current position that NCLAT is taking and had taken in the Technology Development Board of India versus Anil Goel matter is this matter. And however, the judgment of NCLAT itself has been stayed by the Supreme Court. So ideally, in this case, I'm not sure if in the detailed judgment, SIDBI was able to share with the court that your judgment, which was passed in this matter, has been stayed by the Supreme Court. So maybe, I'm not sure if that was shared, but based on these earlier judgments, India Resurgent, ARC Private Limited, and the other judgment, they have decreed that no, this distribution is correct. So we need to look for a final decision from the Supreme Court of India at the earliest, because otherwise this also has the possibility of disturbing the credit finance in the country, in the sense that many banks who give 100% secured funding may shy away from doing that funding in case this is how the interpretation of IBC continues. So this puts them in an inferior position as compared to using SARFAESI or using any other law for that matter of fact to recover this money.
Vivek, anything that you would like to add in this judgment, because this is actually very important, that the security interest is higher, which actually entitles to the bank say for about 5 crores, whereas the amount which was offered was less than 2 crores because of the voting share.
Sir,
And
as Ankit sir,
he must have also used section 30 subsection 4, but then it was because in the word there written is may. So finally the court said that the COC has the power to allocate, and also the COC said that section 53 entitlement. And you can add something which, because
sir,
this is
as
very important.
Ankit sir correctly pointed out that reliance was not placed upon the judgment of your case that NCLAT gave with regard to inter se right between the creditor. Rather, the judgment placed a lot of reliance on Amit Metallic's judgment of Supreme Court, wherein it was decided that the value of security interest would not be considered will not be considered for distribution under the resolution plan. So more or less, this judgment opens another Pandora's box, as Ankit sir has correctly pointed out, that it will decrease the morale of the public financing institutions to have a recourse through IBC, because ultimately they will be not getting to the extent of their debt, but whatever they will be receiving will be to the extent of their voting share under the a particular corporate process.
Right, you are. I think we can take one more judgment and then we can, because already it's 1 hour. So this VK Abdul Rahim versus Justin Joe's resolution professional liquidator.
I can try and quickly summarize that. I
Okay,
recently
you
talked
can do
about
that.
this judgment. So this is the question is whether the resolution professional is duty bound under section 25(2)(b) of the code to take up the issue of counterclaim either before AA or DRT before proceeding with CRP and liquidation proceedings. So the decision is final. We had discussed the counterclaims very thoroughly last time. This judgment says that counterclaims are not required to be decided by the RP. In this case, there was a claim made by a creditor, and there was a counterclaim of the company against that creditor. So the suspended directors or managing directors filed an appeal saying that you have given or accepted the claim of say 100 rupees from this creditor without taking into account the fact that say 50 rupees is pending from or 60 rupees is under litigation, where that might be a counterclaim. So you should accept net claim. So that was something that has been decided the way we discussed earlier as well, that the final decision is that the RP is supposed to accept the full claim, and he's supposed to only talk about that counter claim in the information memorandum, leaving the decision how to manage the whole thing to the resolution applicant. So this has a very, very practical implication. In many cases where there might be performance bank guarantee, which is an unfunded or rather non-funded uh, system, non-funded debt, then in that case, the claim will be admitted. But say there is a margin security or margin available with the bank, which is maybe in the form of FTR or security deposit, which is lying in the assets. So that will again not be netted off with the claim that has been submitted.
So fair enough. Anything that Amar you would like to add in this
No,
case,
sir.
because the counterclaim, because
I
I
think
only would like to add one thing, that these counterclaims were also kind of claims by the borrower, claim of damages from the lenders,
correct.
alleging that they have not supported on time or blah blah. So they
Yeah,
were
they did not give the full disbursement. The project got
yeah.
stuck because all those questions, all those issues are prevalent in almost all these matters.
But
In last,
it is not really a judgment on the counterclaims, because here the claim is also very, very vague, claim of damages. The counterclaim, if it is authentic claims, then I think the judgment would have been different.
sir, the definition, the counterclaim as used here has significance under the civil procedure code. So it is based on that methodology, we call it a counterclaim, that once a bank makes a claim and then whatever you file cross suit will be treated as a counterclaim. So it is a case of cross suit rather than calling it a counterclaim, because counterclaim makes it difficult to have a relation to IBC. We can call it a case of cross suit.
Yeah, it's a case of cross suits.
Mm.
So I think there was only 1 or 2 judgments which was left. So we will try, in case there are more judgments in the month of November. So we will do it as a third part
I
of.
think we can do that in case the judgments are of significant effect. So I think that is
Yes.
important. If there
Yes.
are little judgments to say that, then we can rather think of skipping them. And there are 2 other issues that I would. There is one, an individual insolvency guidance note draft released by IIII. I think one that we can take that up. There is another draft regulation released for valuation under IBC. Because both these valuation is an important process. So understanding the draft regulations before they're even finalized and incorporating the good practices proposed in that regulation would be a good idea for everyone. That we can take up.
Also, like, we are getting feedback that this timing of Sunday 1 o'clock is somehow not suiting many and suiting less people. So even I was thinking, Amar and Ankit, that we can propose like Friday 5 p.m. What
Yeah,
is
or
your opinion on 5 p.m.?
alternatively it can be Saturday, because Saturday is a leave for many bankers. Saturday is a leave for many professionals also. So that can also be thought of.
I think so Saturday is a better option, considering
And
that
What should be the
sometime
time?
Saturday morning 8 to 9 or
Hmm.
maybe 10 to 11,
Morning.
this can
Okay.
be, morning can be thought of.
Saturday morning 8 to 9.
10 to 11 is also
10 to
possible.
10 to 11 is more possible, because I think people would be able to join, more people would be able to join if we do 10 to 11.
So I think we now change our weekly webinar from Sunday. It should be Saturday 10. Because see, like Saturday also we normally have some program, but anyway we'll not have Saturday starting morning 10 o'clock. Is it okay?
Yes,
Or
yes, perfect.
Saturday evening?
Saturday 10 might be, like in a way that 2 Saturdays are off, 2 Saturdays are on. So keeping it before 10 sometimes makes better sense, because people can, those who want to listen to us.
I can see that there are people, they actually would like to do it in their office rather than doing it at home. So even
so we have
Friday,
to decide between a time like 8:30 to 9:30 or 10 to 11. I think 10 to 11 is fine. We can start
or
doing that.
alternatively Friday 5 o'clock.
That will suit far lesser people, in my opinion. So anyways, we will take it forward. I think this is something that we have 1 or 2 votes, but I think that's something that we can't figure out, because many people who are not attending us. Saturday, I think, is the preferred. Saturday would be preferred.
Saturday is preferred.
Yeah, because
not Friday.
during work time, it actually might become difficult for many to join. Saturday
so
8:30.
Should we have Saturday afternoon? Saturday evening means.
Saturday evening is almost busy for everyone. Saturday morning 8:30, I think, can be thought of, or we can think about it more and then come back to everyone.
Then we can actually come back.
Yeah.
So we'll change the next Sunday. It's not there. It may be Saturday or it may be Friday. So we'll accordingly circulate the banner. Yes. Thank you. The meeting is the webinar is concluded. As we always say, that there's no other objective, and it's a collective way of learning. It is our way of learning. Thank you, Ankit. Thank you, Amar.
Thank you, sir.
All right.
Thanks a lot.
Thanks. Bye.